It's October 24th. I am covering Florida versus Sarah Boone. We are in day 5. It is gone quickly. I think overall the attorneys have moved this case along smoothly. There's been some normal trial hiccups, but nothing substantial. There's been some scheduling hiccups that happens, especially when a case is moving this fast. I think the judge is great, but the judge is pushing the speed of this case too. He's like, can we stay another hour? Can we just get it done? So I think they'll be all the way done tomorrow.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Yes.
I hope the judge will reframe what the fuck we're talking about.
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder.
Okay, good, we were right.
And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
All right, page 46, line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that.
That's what she said on the stand.
Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her.
That's what she
talked
said.
About that.
She didn't give me enough criteria.
She spoke about, having recollections, remembering abuse from George during the evaluation.
Is that not what she said on the stand?
113, 146.
That
But
seems...
you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look...
What the fuck are we doing then? Do you think she suffers from PTSD? No. That's an opinion. That's what she... Why are we wasting time?
Back through my notes to see if she fully met the criteria. Question, line 17. Can you explain...
Objection, Your Honor. This is bad for me, and I don't like what she's saying, and my client's mad.
Why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question.
She said no.
Okay.
She said
and
I want.
That's something you will let the lawyers know about if that changes. Answer, line 2 of page 47, yes.
That's why he's mad. She said no. She said I don't have criteria. She said I would want to review my notes.
To the post-traumatic stress disorder.
And that's consistent with what she said on the stand for me. But I wasn't paying that close attention. So I didn't think it was a problem.
I asked her specifically.
So what's the legal objection?
I cannot fucking love this judge anymore. Right. So your problem is what? I love this judge. He lets Owens be heard with all of the nonsense. This trial has moved along quickly, and the judge is like, right. And this is the judge's face right now.
So what's the legal objection?
Bruh.
What are the legal grounds of the objection?
I will
Grounds!
not take that deposition, Judge. When she said, I have not had time sufficiently.
When the judge says, what are the legal grounds? He expects you to say legal words. And those words should be relevance. Whatever grounds it's going to be for not disclosing an undisclosed prior opinion discovery violation, he wants to know the specific magic legal words. And then Owens goes back into, but Your Honor.
to answer these questions, these diagnoses, these opinions. If this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
You took the case.
What are the
Be notified of any changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
There is a book.
I understand the backdrop.
Has all of them. There are books.
I don't know if there's a legal ground other than we had an agreement as attorneys and parties.
Sir, the rules of evidence. I don't know if there's a legal ground. Then why are you doing this?
So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What?
All right, the court has had the opportunity to listen to the proffer as
Denied.
read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
Nope.
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay.
This is procedural.
All right, the court, again, reviewing the proffer and the opinion,
I know.
finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the
What?
opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense.
What?
As it relates to the third category, the effect on the defendant to properly prepare for trial.
What?
Although the questions in the deposition as highlighted by the defense so far are do not address the opinions being
I'm
currently
surprised.
offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens.
Oh, he's giving Owens a chance.
Because my question is, do you want it struck?
I think that's fine. Strike it. I'm surprised by that. Because that's not how I interpreted all of that. I am actually surprised by the court's ruling.
We'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going
What?
to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right.
All of that, and Owens' response is, we're gonna get into it anyway? All of that. We went through all of that, and Owens' response is, I'm gonna ask her about it on cross anyway. So it's fine, send it. Are you fucking kidding me?
With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions,
Proffer
the
it.
court will oversee a deposition now,
Proffer it.
and you may proceed.
Right now?
Yes.
Yeah, right the fuck now.
With regard to the proffered opinions.
You said, I want more time for a depo, and the court said, good, we'll do it now then. I am surprised by that ruling. That said, the judge, I think, has gone out of his way to protect this case. He's giving the defense what they ask for when they ask. He is going out of his way to make sure the defense is giving legal grounds for what they're doing. And even when they don't, he is still finding in their favor. And now Owens is like, what? Wait, what? You're going to give me what I want? Wait, what did we ask for again? Dead. I'm dead. I'm dead.
And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard
Right.
to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time.
Okay, Your Honor.
The court has
Wow.
conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition.
I think that wasn't a
Anything
abundance
else, sir?
of caution. Well, I think I said when I started stream today on day 5, October 24th, 2024, that this trial had gone smoothly till now, that the attorneys have worked well together, that things had been moving right along. And I jinxed it. Because the second we got into the state's rebuttal, all of the wheels came off. More time was spent today with the jury out of the courtroom than the jury in the courtroom. There were so many sidebars. I think that the witness on the stand, the state's expert, gave maybe 10 contiguous minutes of testimony, maybe a little bit more. It was difficult to follow because of the amount of objections. The defense is fighting everything this witness says. And it's because it seems that what the state's witness is testifying to, and I say seems because between all of the sidebars, arguments, and everything else that happened, it is hard to piece together what this expert actually testified to. This is my best guess, even after multiple readbacks, is that the expert from the state is testifying that based on Sarah Boone's recitation of the events to the expert in the evaluation, that it is the expert's opinion that PTSD and battered spouse did not come into play here because nothing triggered Sarah Boone that day. I don't think the expert even said it that clearly. So I think what the state elicited was that she didn't think that Sarah Boone gave her enough information to determine whether or not PTSD was at play here. And she did not believe that PTSD and battered spouse were at play for this incident based on the way Sarah Boone described it in her evaluation. There was a ton of outside the presence of the jury conversation where Owens is fighting to keep this expert's opinions limited and out. And then he's just opening up all the doors on cross, which he just started before the lunch break. At the longest argument outside the presence of the jury, Owens was arguing that there was a discovery violation, and we ended up having a discovery violation hearing and a deposition of the expert and a proffer of the expert's testimony. The defense is arguing that the expert rendered an opinion in court that was not given in deposition and was contradictory to what was given in deposition. The state said, no, this is in line with what she said at deposition, but she didn't answer my question specifically. So I was expecting her answer to be this, which she said in depo. And this answer was slightly different. The court found that there was a discovery violation, which surprised me, and found that it was inadvertent, but that it was substantial and there needed to be a remedy. The defense asked at one point to strike the entire expert. And the court's like, that's a draconian remedy. I'm not going to do that. But would you like me to strike the answer? So do you want me to strike the answer that the jury's already forgotten because they've been out of the courtroom for so long? Do you want me to strike the answer that you don't think, that the expert doesn't think that PTSD was at play here, or that there was enough information for her to determine whether or not Sarah Boone was suffering from the effects of PTSD? And Owen said, no, because I'm going to get into it at cross. So there was like an hour of them going back and forth on the record. The court found a discovery violation for the state because the answer was different. The state, it found it was inadvertent because the state was like, we thought she was going to answer this way. It was slightly different. And then the court said, the remedy is we can strike the answer. And Owen said, no, I don't want you to strike the answer. And the court's like, okay, then I will allow you to depose the expert. Go ahead. Ask the expert all the questions. So Owens asks her a handful of questions and then sits back down. The court's like, are you sure you're done? And then Owens gets up, and I thought his questioning of the expert went badly for the expert. Owens was like, well, what else did you not tell us? And she's like, if you answer a specific question, I'll give you a specific answer. But I'm not just going to answer a catch-all question. So Owens actually said, so you said you needed more information and you'd give us this information later. And she said, well, I rendered that opinion after my interview with Sarah Boone, and I actually told the prosecutor as we were leaving the jail. But it seems that the prosecutor didn't retell that to the defense, which doesn't look good for the expert. So then they get back on the record, we get into cross-examination, and there is sidebar after sidebar after sidebar. This testimony might be completely worthless to the jury, or it might be the most fascinating thing that has happened to them in the last 5 days. It has been hard to file. It has been wild. It has been completely off the rails. We have seen the judge get frustrated. The expert witness has been sitting on the stand the entire time they're arguing about her. She looks frustrated. Occasionally she looks at the jury and is just like, he's doing it again. He's just doing it again. And I am just stunned as to everything that's going on here. I'm surprised that the judge is ruling about the discovery violation, because I think based on all of the readbacks they did, that it was in line with what she said in deposition. If the court is seeing a scintilla of a whiff of a LaCroix of indication he can grant the objection, he is. And I think the court fashioned a fair remedy to allow the defense to depose it in court, allow him to ask the questions of the expert before cross-examination, and that's the remedy. And so now Owens can't say, I didn't have an opportunity. The opportunity is now. She is here. And then Owens tried to stall his cross-examination until after lunch to start to put it together. So now that we are at lunch after multiple sidebars and maybe a minute or two of testimony, we'll see what happens after lunch with this expert. I don't think Owens is done, because the state did not elicit that this expert does think that Sarah Boone's suffering from battered spouse or the impacts of battered spouse. The state didn't elicit that on direct. The defense was just trying to elicit it before lunch on cross. She said it in her deposition with the defense, and they haven't had a chance to get into it. This could go well for the defense, but this could go badly for the defense. They've got an opportunity. We'll see what they do with it. I am wondering why there are moments where the state just seems to kind of give up. I don't know if they're overconfident in their case, but the state at times has just been like, okay, fine. And I'm stunned by it. After a longer day than I anticipated, and we are only at the afternoon break, the prosecution's expert witness is finally off the stand. There was so much arguing about what this testimony would be. And at the end of the day, the thing that I remember most is that Attorney Owens asked the expert, do you agree that Jorge Torres was the aggressor and Sarah Boone was the victim? And she said, well, in reports, Sarah Boone's ex-husband, Brian Boone, said that she was the aggressor. And that is, I think, a wild error for the defense to elicit that testimony. Do you know what else Owens elicited after all of the fighting? After all of the fighting today, he said, so do you think Sarah Boone has PTSD? And she said, Sarah Boone did not give me enough criteria to make that determination. That's what the entire fight was over this morning. And then he elicited it. And then it allowed the prosecution to get into rebuttal. And when the prosecution got into their rebuttal, I think it was actually more informative than their direct examination. On their rebuttal, they were able to ask about, again, do you think that battered spouse syndrome applies in this case on these facts? And the expert was essentially able to say no, because Sarah Boone said that they were laughing. She didn't say that there were any triggers. She didn't give any information that would have put this into the category of her acting out of that trauma or duress. And that testimony came in again. And then, because the defense pulled out all their blow-ups of their photos, the prosecution went photo by photo. Does this tell you what happened or who was the aggressor? No. Does this tell you what happened or who was the aggressor? No. And it kept going. So I think the prosecution had a better redirect than they did direct examination. And I think the defense made some points early on in the cross and then stepped in it at the end of cross. At the end of day 5, we are almost at the end of the state's rebuttal. They have a 108-page document of text messages to get through. There was more going on with the expert from the state after the lunch break. However, it has been completely wiped from my mind due to the fact that we spent hours watching video of incidents where the police came out to the apartment, and we spent a little less than hours watching videos Sarah had taken on her phone of the victim, in this case, Jorge Torres. It looks like the prosecution is going to really close out their case with videos of the victim. Not only is it a little chilling because even in the arrest videos, you hear George saying Sarah the exact same way he does in the video of him in the suitcase, but you also hear Sarah saying things like, "That's my name. Don't wear it out." The videos I found to be incredibly impactful. You see Sarah coaching George about what to say to the court. When the police show up, you see George saying, literally hunched in on himself, cuffed behind him back, sitting on the edge of the bed saying, "It's just all my fault. It's just all my fault. It doesn't matter what I say to you. It's just all my fault. It doesn't matter. There's a stay away order. It doesn't matter what I say. It's just my fault. It doesn't matter." The videos are going to be this case. When I said originally that I thought the video was going to be this case, I thought it would be the suitcase video. I had no idea what videos the state would bring in the rebuttal case. And if Sarah Boone hadn't chosen to run a battered spouse defense, a lot of those videos wouldn't have come in. It was difficult to watch. It was incredibly sad, but I think it will be very informative to the jury. You see the demeanor between the two, you see the tone of voice between the two, and the other thing that's clear in this case is the alcohol use. It's just sad. I probably have stronger words for it, but I'm kind of reeling from what we saw. So early on in this case, I was like, the prosecution's not really going after Sarah in cross-examination. They cross-examined her expert more than her. And now it makes a lot more sense why. Because at the end of the day, the prosecution was going to push play on this case in their rebuttal, and they knew exactly what those videos were going to show. And so they're not going to cross-examine her and give her a chance to explain. They're like, "Okay, you said what? You didn't tell the police that before? Okay. Okay. What stuck out to me is that you saw from the defense expert a lot of testimony about how long it can take for victims to trust law enforcement or experts to disclose what had happened to them. And in all of those videos, you saw that from George. You saw Sarah saying, "This is everything that's going on." And then you saw her, I don't want to say gleeful, but it was gleeful. She was also inebriated when the police were arresting him and taking him away. But you also saw him not being willing to say anything. And the police are like, "You're not giving us a straight answer. You're not telling us what's going on." And he was sitting in the back of a police car crying. "You're not telling us anything. You're being vague. She said all of this." So I wonder if how the experts testified will stick out in the jury's mind as they watch those videos, or if they'll watch those videos and just be like, well, that gives more context. So tomorrow, the prosecution will be resting their case, it seems, with just the text messages coming in. The defense attorneys have said, we don't think there's going to be a rebuttal. Sir, there's not going to be a rebuttal. We also learned more about the bike. We heard about that on a 911 call where Sarah calls 911 and said that George came back to her apartment. She had taken him off the lease, came back to her apartment and took the bike that she bought him. So it's basically still hers. The 911 dispatcher said, ma'am, that's a gift. That's his. And she was like, well, he came and took the bike and he came and took this and that. You heard George telling the police that he came over to the apartment because she was holding on to his license or his ID and his birth certificate, and that he couldn't cash his paycheck because she was holding on to his documentation to go get his paycheck cashed. And that's why he had gone over to the apartment, because he couldn't get it cashed and she had taken him off the lease. But it seemed that she was mad because she wanted money for the rent from him, but then held on to his documentation so he couldn't go and cash his check. So we can now see a little bit more why the prosecution was asking about taking things back, which was a mode of transportation, holding on to necessary paperwork because he couldn't cash his paycheck without it. And you start to see where the state was building their case, and it is difficult. So if you've been watching this trial with an open mind, I wonder if you feel a little bit of whiplash from the day, because it's like, wait, what? And that is why they always tell a jury to keep an open mind until all the evidence is in. It's going to be real interesting to see what of those videos the prosecution brings up in closing, and it'll be interesting to see how Owens closes. I can also see why Owens was fighting the expert that said, though Sarah does have the traits of battered spouse syndrome, that doesn't apply here. Because that's really what the state's expert ended with. It doesn't apply here. And in fact, the defense opened the door. We never would have heard in this case that Brian Boone thinks Sarah is the aggressor in this case if the defense didn't ask that question. So that's what the jury heard today. And I wonder, after seeing those videos, if there's no doubt for them about that. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.